and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the country. Let's take a look at the headlines. Plea in Supreme Court seeks contempt action against SEBI for delay in filing reports in the Adani Hindenburg case. Supreme Court hears pleas by Tamil Nadu and Kerala government against governors for delaying assent to bills. Delhi High Court directs constitution of committee for implementation of 6th and 7th pay commission in private schools. Haryana Government to approach Apex Court against High Court order, declaring 75% reservation in private jobs unconstitutional. Uttar Pradesh Government bans sale of Halal certified products. Now the headlines in detail. A plea has been filed before the Supreme Court, seeking the initiation of contempt proceedings and a direction to submit an explanation by the Securities Exchange Board of India for not complying with the deadline to investigate and submit its report in the Adani Hindenburg case. Advocate Vishal Tiwari, the petitioner in person for the case, informed the Apex Court that SEBI has failed to adhere to the directives issued by the court, specifically by not submitting the final report within the stipulated deadline. In a recent application, Advocate Tiwari urged the court to issue various directives, including the direction to the expert committee to conduct a thorough investigation into the alleged allegations of stock manipulations and secret investments outlined by the Organized Crime and Corruption Reporting Project recently. The petitioner also sought court orders for the implementation of suggestions and measures recommended by the expert committee. Previously, on March 2nd, the top court had ordered SEBI to probe within 2 months the allegations of fraudulent transactions made by the Hindenburg research report, and an extension of 3 months was granted on May 17th, upon considering the report by the 6-member committee led by Justice A.M. Sapre, appointed by the Apex Court itself. On August 25th this year, SEBI filed the status report regarding its investigation that was carried out in compliance with the top court's order, indicating that out of 24 investigations arising from the Hindenburg report, 22 are final and 2 are interim. The Hindenburg report, released on January 24th, alleged manipulation of stocks and fraud by Adani Group. The Adani Group, however, vehemently criticized Hindenburg, characterizing as an unethical short seller, while refuting the allegations and dismissing the report as baseless. A short seller in the stock market books gains from the subsequent reduction in the price of shares. The Supreme Court's 3-judge bench, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice J.B. Pardiwala and Justice Manoj Mishra, today heard 2 separate pleas from the government of Tamil Nadu and Kerala, alleging delays by their respective governors in granting assent to bills passed by the state assemblies. In the case of Kerala, the government moved the Apex Court, claiming that Governor Arif Muhammad Khan is causing delays to assenting to 8 bills, and urged that this inaction by the governor led to the denial of benefits and welfare of people of Kerala. The Kerala government contended that this conduct of the governor posed a threat to the constitution, including the principles of democratic governance and rule of law. The top court today issued notice to Governor Khan's office, along with center in the matter, seeking a reply. In the case of Tamil Nadu, 10 bills were re-adopted by the assembly after being returned by the governor R.N. Ravi. The Tamil Nadu government in its petition accused the governor of consistently acting in an unconstitutional manner and impeding the functioning of the state government. Earlier, the top court also expressed concern over the alleged delay for giving assent to bills by the governor and sought the response of the central government and the assistance of the Attorney General or the Solicitor General in resolving the dispute. Notably, the bills are sent to the governor for assent under Article 200 of the Constitution of India, which provides that the governor shall declare either his assent or he can withhold his assent. The same article also provides the governor with the power to reserve the bill for consideration of the President, but the said article does not provide any time limit for giving assent. The Delhi High Court has issued directions to the city government to constitute a high-powered committee to supervise the implementation of the recommendations and guidelines of the 6th and 7th Central Pay Commission to private schools. These recommendations pertain to the payment of salaries and arrears to the staff of private unaided schools, as well as recognized private unaided minority schools in Delhi. emphasizing the significance of education as an invincible weapon for empowering future generations. The High Court stressed on the need for a regulating authority to exercise control in order to have consistent and high quality of education for every student of the nation. The High Court order provided that the committee be established both at central and zonal levels. Additionally, the Directorate of Education has been directed to issue a notification within a period of 2 weeks for the purpose of convening a zonal committee. The committee will function as a platform for various stakeholders, including both the teaching and non-teaching staff from different schools, and play a crucial role in facilitating communication, resolving disputes by allowing the aggrieved parties to file a claim before the panel. Deputy Chief Minister of Haryana, Dushyant Chautala, has said that the state government will knock the doors of the Supreme Court against the order of the Punjab and Haryana High Court that declared the law providing 75% reservation in private sector jobs to residents of Haryana unconstitutional. The Jan Nayak Janata Party leader, in a statement, asserted that the law was in the interest of the state and the industry. The verdict that came following several petitions filed against the government's order against the implementation of the act was also a major setback to the political party of Chautala, who promised the reservation during 2019 state assembly elections. The law came into effect on January 15, 2022 and was ruled to become ineffective from the same date by the High Court on 17 November. The government of Uttar Pradesh, led by Chief Minister Yogi Adityanath, has banned the production, storage, distribution and sale of halal certified food products with immediate effect. The official press release outlines stringent legal measures against individuals and businesses involved in the production, storage, distribution, buying and selling of halal certified medicines, medical devices and cosmetics in Uttar Pradesh. Notably, products destined for export are exempt from these restrictions. The press note highlights concerns regarding the labeling of certain items, such as dairy products, sugar, bakery goods, peppermint oil, ready-to-eat beverages and edible oils with halal certification. Additionally, it points out that halal certification is being applied to products despite the absence of provisions for such certification by the relevant government regulations, and such certification operates parallel to the established standards. The press release also said that halal certification harms businesses' interest of other communities and an unrestrained propaganda is being disseminated within a particular section of society to discourage the use of products lacking such certification. The communication also stressed that any explicit or implicit reference to halal certification is considered falsification under the Drugs and Cosmetics Act of 1940 and is subject to legal consequences. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.